have seen that, and it is really, really sad. I mean, I don't know what the answer is to that, because although there are penalties, you know, for obviously perjury, lying, you know, to the court, there are penalties, you know, for people who don't allow, or for mothers who don't allow fathers to see their children and break court orders, you know. But sometimes part of the problem is a lot of the fathers just don't want anybody in their business. They don't want to answer questions. They don't want to be interviewed. They don't want to, you know, they don't want to be tested. You know, it breaks my heart when a father says, you know what, I'm just not going to bother. They can come and find me when they're 18. A lot of times they won't come and find you when they're 18. Or if they do come and find you, it will be basically to tell you about yourself and say, why didn't you, you know.
What's going on, people, and welcome back to the Baby Fathers podcast for another brand new episode. I am your host, and I go by the name of DJ Ridler. Now, on today's show, it is a different show, but before we start today's show, I need you lot to do me one thing. Make sure you subscribe to the channel and don't forget to give us the thumbs up for the likes, all right? So on today's show, we have another special guest, and she goes by the name of Arlene. How you doing, Arlene?
I'm fine, thank you.
How are you?
Good, yeah, very well. You?
Not too bad, not too bad. Listen, I want to say thank you for coming.
It's all right.
This has been in the making for a few months now because you've been very busy.
Yep.
Can you let people know exactly what you do?
Okay, so I'm a family barrister. I basically go to court and represent individuals who are going through different challenges within their family, whether that is separation, sorting out children. I deal with divorce. I deal with all the issues that people come up against when sadly things go wrong in their relationships. So that's primarily my role, providing legal advice, legal assistance, and also, as I say, court representation when people need it.
So when did you become a family barrister?
Okay, so I'm actually come October, I will have been doing this job for 26 years. So about 5 years into my practice, I decided to specialise in just dealing with aspects of family law. At the time, it was mainly families whose children sadly had been either removed or there was some intervention by the local authority because of issues of neglect or concern about how they were being brought up. And then gradually I moved on to dealing with just individuals whose relationships had broken down, people who were separating, people who had lived together and then separated, or people who were married and then separated. And so that's been going on for, basically the last 20 years or so. Okay.
So what makes you different between a solicitor and a McKenzie friend?
Okay, so I should say all three are, if you like, aiming to do the same thing. We're all aiming to help people who are going through difficult circumstances at court. Historically, what used to happen was you would go to a solicitor. They would be on the high street, so you'd see the office or the sign outside, Smith & Co. or John & Co. or what have you, and that you would go in and you would tell that solicitor what your issue was. They would take that information from you, and the only time you'd really see a barrister is when you went to court. The simplest way to sort of, I suppose, tell the difference is if you saw a solicitor standing in court and a barrister standing in court, and mainly criminal court, let's say, the barrister would be wearing the wig, and the collars and gowns. Both sides wear collars and gowns, but barristers mainly wear the wigs. But barristers' speciality is bringing the case in court, so talking to the judge, questioning witnesses and so on. That's the main difference. And both have legal qualifications. Both will have gone through training to get to where they've got to. McKenzie friends, it's a bit stricter now, but a McKenzie friend could really be anybody that you wanted to come to court to help you. And the main difference is that they don't have what's called rights of audience or the right to address the court directly. A barrister does, a solicitor does if they've done all the additional training, but McKenzie friends it could be your cousin, it could be your auntie, it could be, that was back then. Now, McKenzie friends go through training as well, but they're still not allowed to speak on your behalf in court unless the judge gives them permission. Okay. The other key thing, because I know that a lot of people will use McKenzie friends, but another key thing is that McKenzie friends don't have what's called professional insurance. So if something were to go wrong in your case and you took advice or from a McKenzie friend, then you may be in difficulties down the line trying to say, well, you gave me the wrong advice. Whereas barristers and solicitors, we have to have professional cover so that we can actually give the advice that we give. And in fact, it's a criminal offence to hold yourself out as a barrister or a solicitor when you're not. So McKenzie friends are pretty clear. We're McKenzie friends. We're not lawyers. We're not giving you legal advice per se, but we are able to support you as you're managing your case.
Okay, so what is the law in family court when a father is being stopped for seeing his child? Well,
I mean, that's a really sort of loaded issue, because fathers being stopped from seeing their children. Normally what happens, and everybody's probably got their own story to tell, but when parties separate and they've had children, the thing that kept them together, so the love, the romance and all that tends to disappear pretty quickly. And what you're really left with is just two people now trying to work out how to parent a child. So what tends to happen is, in those early stages, everybody's just muddling through. So there isn't a law, as it were, that says, or a way in which the law allows a mother, or a father for that matter, because either one could be the main carer, to stop the other parent from seeing the child. What tends to happen is, either there are issues over practical things like who's going to take the child to school, where the child's going to live,
money
is another one. Health, sometimes to do with if there's a treatment they need to have or not have. Those are the kind of things which then, if you like, seep into whether a parent can see a child or not. Because once people start falling out, the easiest thing is to say, I don't want to see you, and I don't want you to see the child, because you seeing the child means I have to see you as well, and I don't want anything to do with you. So it's not that there's a law that stops parents. It's really down to when parents just can't work things out with each other. That's normally when, sadly, the child gets caught in the middle, and then the contact just stops altogether.
On this show, we had quite a few fathers who's coming on who has been through the whole court process in the family court.
Yeah.
And one of the highlights things that we seem to always come across, that the mum seems to lie a lot in court and able to get away with this. Tell us a bit about that.
Yeah, well, I mean, again, it's all loaded, and I'm sure there's people who will listen to this podcast say, I mean, I've represented fathers who have care of the children, and the mother is what we call the non-resident parent. And in those instances, I've seen fathers, say, well, no, the child doesn't want to go, doesn't like the mum, doesn't, and vice versa. So I know this is a baby father podcast, but I just want to make it clear that it does actually go both ways. So when people talk about lying, I like to think of it more like as a perspective. So when people separate, as I say, the mother or the father will have a particular perspective on what's taken place. I mean, don't get me wrong, there are blatant lies that go down, and as long as you have evidence to prove that, then the truth usually does come out. Okay. I tell you, the main difference I find is that the mothers tend to be a little bit more sophisticated. They tend to document things a bit more. So they will keep diaries, they will keep records, they will keep WhatsApp messages, they will keep emails, they will keep a paper trail of what's gone on. The dads, they're catching up a little bit, but there are times where they will say things, and when I say, okay, well, show me where, they say, oh, I haven't got that message anymore, or oh, I've changed my phone, or oh, I deleted this, or I deleted that. So I think that the difficulty that sometimes comes out is, it's not that the person isn't lying, it's what can you prove? It's what evidence do you have to show. For example, if a mum says, he turned up at 6:10 instead of 6 o'clock, or 6:30 instead of 6 o'clock, and by that stage we'd left. If you were there at 5 to 6, then a lot of people will do things like they'll text the mother at 5 to 6 and say, I'm here outside the station, or I'm here at McDonald's, wherever it is, so that if the mother then turns around and says, oh, I was there at 6:15 and you hadn't turned up, the father can say, I've got this text message here, it shows I've texted you. And okay, yes, people can fabricate things, but that's more likely to get the court's attention if you've got something to say, I was there, the mother never turned up, and the contact didn't happen.
So another thing I was going to say to you, because we've also been having a lot of this DV allegations, what seems to be getting made against fathers, which majority of them doesn't seem to be the truth. So in terms of this actually happening in court, how are they able to address this?
Yeah, I mean, there's been a whole, I'd say, a movement really in the last 2 or 3 years. I mean, it's been there all the time, but I think now judges are very concerned about sending children into situations or encouraging contact in situations where there has been domestic violence. I mean, I have to say, I think my view is I think the process is quite stringent, in as much as if somebody makes an allegation, it's not that, oh, right, okay, you've made an allegation, right, okay, we believe it. That's it. You know, there is a whole process, again, that people have to go through to actually prove what it is they're saying. And I have seen, again, both sides where allegations, which is quite clear that, you know, that nothing's has happened, but somebody has decided to use that allegation as a means to stopping someone to see the children. And as I say, 9 times out of 10, what happens is that the truth does come out. The difficulty is it takes a long time and it can be very expensive. And there isn't, even if somebody is proved not to have told the truth about something, it's not as if the father, for example, gets the money back, or whoever made the allegation, you know, it was wrongfully accused, gets their legal costs back. So that's what tends to put a lot of fathers off, that it means that if they spend all this money, all this time, this person's lying, you know, why can't we just short circuit it and say they're lying? But there is a very, very long process for the person needs to go through. So I'm not saying, again, it doesn't happen. When you say, how can they address it? They have to go through that process. There's no shortcut to that. Sometimes a judge will say, we don't need to go down this road because, you know, you're already seeing the child. Even though there's allegations, you're already seeing the child. How is having a trial about that going to help? And that it can get short-circuited in that way. But the bottom line is, sadly, I say sadly, or unfortunately, but some people would say it's the right way. You have to persevere. You have to, if you know that you haven't done these things, you have to go through the process. You have to get your evidence together, present your case to the court. And as I say, my experience has been that the truth does come out. The truth does come out. And you know, fathers that persevere do eventually prove that they haven't done what they're accused of doing.
You said something what kind of caught my ear just there when you said that in the last few years, the court system is obviously taking this more seriously now about this DV. Do you find that sometimes some mothers will use that as a weapon to make it more difficult for a father, knowing that that's a card that they can use? I
mean, there's sort of, I think there's kind of 4 things which you can kind of throw out, as it were, or put into a case that will get the court's attention. Domestic violence is one of them. Drugs is another one. Mental health issues is another one. And I don't mean just saying my partner's crazy. That's not a mental health issue. I mean a diagnosed mental health issue, because everybody thinks their ex is, you know, a little bit out there. So mental health. And the other one is criminal activity. So the moment that you mention any of those 4 things, it becomes what's called a safeguarding concern. And some of your viewers, listeners will know, for example, about CAFCAS, who go in and do welfare checks, particularly where there are those 4 things. So are there mothers out there that will think, oh, what can I do to, you know, to, as it were, cause difficulties? Yes, there are. Equally, there will be mothers, women who have gone through these things. But I, you know, it's difficult to say because every case is different. But I think the key thing is for fathers, you have to persevere. If you know you haven't done these things, if you know for a fact that you are being wrongly accused, for example, of being violent, that you're being wrongly accused of having a mental health issue, of being a criminal, you know, or any of those kinds of things, or, you know, you've got to be able to be willing to be tested, because that's the other thing. And when we go on to things that fathers could do to help themselves, I'll talk a bit more about this. But sometimes part of the problem is a lot of the fathers just don't want anybody in their business. They don't want to answer questions. They don't want to be interviewed. They don't want to, you know, they don't want to be tested. You know, so for example, if someone says, he drinks a lot of alcohol, you know, I know he's drunk all the time. The easiest thing is to say, do you know what? Test me. All right, just test me, and the test will prove, you know, what I'm saying is true. But a lot of, and it is particularly, I think sometimes culturally as well, particularly in the black community, we don't want anybody in our business. It's like, I'm not going to be tested. No one's going to, why are you asking me questions? You know, that is the surefire way to arise suspicion. And what tends to happen at that point, it's almost like you've now handed your ex-partner the weapon with which to beat you with, because they will be saying, well, if you haven't got anything to hide, why are you not being tested? Do you see what I mean?
Yeah.
9 times out of 10 as well, what also happens, even if someone volunteers to be tested, sometimes the court will say, we don't need to take, there's no, apart from the mother saying it, There's no evidence that says that, no one's ever seen you under the influence. No one's ever, had any concerns about you being under the influence. So the court will do its job and say, we're not ordering any testing. But that is better than you saying, I'm not going to cooperate with this.
But then in court, is it based on the judge? Because by speaking to some fathers again, because they do come on this platform, right?
Yeah.
They do say that some of the judges, because there is some good judges out there, but some of the judges literally just looks at them, don't even allow them to even talk. I really made up their mind about them.
I mean, that depends on, it's not ideal, but I have to say, and I know, again, money is a big issue when you're going to court. It's a big issue. If you can't afford representation, you're going to struggle in some areas. When I go to court, normally it's helpful if both sides have lawyers, okay? But in situations where there's only one lawyer, the judge 9 times out of 10 again will defer to that person who is legally represented. So if a father turns up and he's on his own, and a mother turns up and she's legally represented, even if it's the father that's brought the case, the judge will usually say something like, well, Mr. Smith, I know it's your application, but you're unrepresented, so I'm just going to ask, if it's me, I'm just going to ask Mrs. Small to just tell me a bit about the case. So already the father feels, I'm on the back foot. It's my case, but you're starting with the other
barrister,
side. Exactly. Yeah. Who happens to be there. So what those fathers are picking up is not necessarily that the judge may have prejudged them. It may just be that the judge is thinking, how am I going to get the information that I need quickly and in a form that is helpful to the court? Because sometimes people come to court, they've got lots to say, but that's not necessarily what the judge needs to hear at that time. So that sort of thing sometimes does take place, and it shouldn't. I agree, it shouldn't take place. If somebody comes to court by themselves, they should be given the same level of deference, if you like, as the person with the barrister. But the reality is the judges themselves, they're under pressure, they're short of time, they might have 5 other cases outside, they might need to move things along quickly. So I'm saying that the fathers that you've spoken to are probably right. They probably have picked up something, but it's not necessarily what they think. Okay. It may just be that a judge is wanting to move things along. Sometimes as well, and I can say this because I'm a woman, once a woman start talking, it's hard to stop her. So the judge might be thinking, I don't want to interrupt her, so let her just and then father's sitting there thinking, she's eating out all the time.
Yeah.
By the time the judge comes to me, it's like, okay, well, thank you very much for coming, Mr. So-so. We've got to wrap it up now. So there's lots of things that are happening in the courtroom that unless someone's explaining it to you, it may feel like you're being judged, but it's not necessarily that.
So with this molestation order, how does this whole thing play out? Because I keep hearing fathers keep bringing this up.
Yeah. Again, I think it's a lot to do with the way that the court system now is trying to be sympathetic. It was thought for a long time that judges particularly weren't taking the issue of domestic violence seriously. Well, not just judges, but police officers as well. There was this whole thing about, if you call a police officer for domestic, they're not going to turn up because they think as soon as they go, you're not going to want to press charges or the mother's not going to want to press charges. So now it almost feels like the system's gone completely the other way. So the non-molestation order is meant to be used only in situations where an individual has been either threatened with violence or there's been actual violence, or there's been some sort of domestic abuse situation. Domestic abuse can now include not just physical violence, but as I say, verbal, coercive controlling behaviour, financial control. So it's a lot, the definition is a lot broader, and people will find now that, the old fashioned view that, if there's no, you have to have a bruise to prove domestic violence, that's no longer the case. So judges have become a lot more sensitive to the ways in which people can be victims of domestic violence, and that's both men and women. The issue is that a lot of times people come to court and you can actually get a non-molestation order against somebody without them even being present.
Okay.
You can do it on an emergency basis. It's one of the applications where there's no, you don't even have to necessarily have money as such, because there's no fee for those kind of applications. There are lots of organisations, primarily women's organisations like Women's Aid, who will help you to prepare the documents that you need in order to go to court. So what tends to happen is you'll have somebody come to court and say, this incident has happened, I've been physically threatened, or I've been verbally abused, or I'm fearful, or I'm anxious, and I'd like a non-molestation order.
Without the father not even being there.
Without the father not even being there. Or anybody even, as I said, I know this is a father's podcast, but I make it clear again,
100.
if a father was to do the same thing, they would also have the same opportunity. And those orders are granted without notice. So in other words, what normally happens is the person who's applying will say, if I let the person know I'm going to court, they will threaten me to not come, or they'll intimidate me into not coming. So that's why I'm coming on my own. Having said that, once that order is granted, if that order is granted, then, and it's given to the father, let's just say this instance, the father then has the opportunity to actually make an application to court and say, I want this discharged because I haven't done what this person says I've done.
But then do they have to then do a fact finding to see if it's true or not?
Well, yeah. In some instances, there's two ways they're normally settled. They're normally settled either by what's called three ways, I should say. Undertakings, which is basically the father coming to court and saying, look, I haven't done this thing, but I'm willing to give a promise to the court that I'm not going to behave in that way. Some fathers are happy to do that because they think, you know what, I don't really, as long as it ends today, I don't have to come back, I don't have to spend money on a lawyer, then I'm quite happy to give the promise to the court. Or the court can say, okay, an undertaking's not suitable here. In other words, an order is needed, and I'll explain why in a moment, but an order is necessary. Are you content for the order to remain in place without you admitting anything and without any findings being made against you? Some fathers are okay with that because it's like, I haven't done anything. You can have your order. I stay away from you. You stay away from me. We all just get on with our lives. The third way is if you contest the order. In other words, as you say, a fact finding takes place to work out whether the things that you're accused of are actually true. And then that is the one that means you end up having a trial. The main difference, and sorry to get a bit technical here, but the main difference between an order and an undertaking is that if you have a court order, a non-molestation order, it has what's called an automatic power of arrest. If you break it, you can be arrested straight away. Okay. An undertaking doesn't have that. Someone has to prove that you've broken it before the police are likely to take any action. Having said that, obviously, if you're at risk of harm, the police would get involved anyway. Yeah. But yeah, nowadays it can seem like it's pretty easy to get a non-molestation order, and I know a lot of fathers are, they're really unhappy about this. You've got a non-molestation order. Why have you got one against me? I haven't done anything. But equally, they don't have necessarily the resources to challenge it, so they just let it ride out for the 6 months or a year that it's in place.
And is this being put in place that you see, like when these mothers are going to these organisations, do you feel that they kind of just using that as a way of trying to delay a father seeing it? So they tell, I just say this because you're able to get it to go this way for yourself. Yeah.
I mean, I have seen that, and it is really, really sad. I mean, I don't know what the answer is to that, because although there are penalties, for obviously perjury, lying, to the court, there are penalties, for people who don't allow, or for mothers who don't allow fathers to see their children and break court orders. The court has the power to fine a mother, to send a mother to prison, to order community service. The reality is that, I mean, in 20 years, I don't think I've ever had it happen to any of the mothers that I've seen. I had one mother come to court with her toothbrush because she genuinely thought she was going to prison for not allowing the father to see the child, but it didn't actually. I mean, she went home with the toothbrush. She didn't get locked up. So I mean, I don't know if the solution is mothers should, if a few more mothers were in prison, maybe all of this would stop.
Yeah.
But what judge is going to do that? What judge is going to put a mother in prison? I think it's there just does not seem to be any answer.
So when the father goes to court to do the fact finding, does he have to pay a legal for someone to represent him?
Yeah, I think it's really risky going to court on a fact find without a lawyer. And there are no guarantees, but I think you stand a better chance of presenting your case in the right way. I find that when particularly fathers go to do fact find, they the emotion that they put forward. They're not always focusing on, what they have to say and do in order to present their case in the best possible light. I mean, even, if I had to go to trial, I wouldn't represent myself.
Yeah.
I just don't think you can be objective enough. I know why people do it, and I know that people have had some bad experiences with lawyers. They've paid loads of money, and the lawyer, in their words, has been rubbish. Yes, I know that those things have happened, but I still think on balance, it's better to have somebody speaking on your behalf than you trying to do it yourself.
So do you think that the court system is broken?
I think it's got some serious, if it's not broken, it's certainly rocky. And that's really, I know that we blame COVID for everything, the world wars and everything. But the reality is that period of lockdown, it put a strain on a system that was already in difficulties. And I'm talking about things, even for things like trying to phone a court. If any of your fathers have ever tried to call a court to find out what's going on, I've been on hold. There's no special back door for barristers, by the way. Okay. I've been on hold for nearly an hour waiting to speak to people, court staff and what have you. And that's really because when COVID came about, they'd already started to try and scale down how many staff they were having in the court building. Court counters were closing down. So whereas before you could walk up and ask questions about your case, now you had to ring a number, try and make an appointment, and hopefully, you'd get in before a week or two if you were lucky. Now it's taking longer. It's taking 3 weeks, 4 weeks. So the system itself, in terms of just bringing a case to court, even getting information about what form to fill in. If you email a court, you get something back that says, we don't give legal advice. The whole thing is a struggle. Once you're actually in the system, I think it works pretty well. Apart from, as I said, things like waiting for court dates. Some people are waiting 6 months. Sometimes people come back the following year. Sometimes you get a call the day before. Sorry, we haven't got a judge available for you. That's, again, pressure on the court system. So I wouldn't say it's broken, but I would say it's definitely, it's in need of some repair. Okay. You know what I mean?
So if a father was making a complaint about the court, does that affect his case?
No.
Okay.
No. The people that run the courts, as it were, or run basically have the power to make decisions about your case. They're not interested in whether you've complained or not. When I said they're not interested, that's not what influences a decision. 9 times out of 10, they won't even know about the complaint. Because, when you say complaint as well, if it's a complaint about how you've been treated by a member of the court staff or something, that's one thing. If it's an issue about, the decision, that's what the appeal process is there for. Do you know what I mean? And once you've got yourself into the appeal system, that doesn't affect how a judge sees your case. It just means you're entitled to appeal. It's your legal right. If you're not happy and you feel that the court has done something wrong or the judge has made the wrong decision, you're entitled to appeal. So people should never feel that because they might have made a complaint about a judge or so, that it's suddenly going to, affect their case. I'm sure people listening going, yeah, right, yeah, sure. But my experience has been, not in a horrible way, but you've got good and bad in all professions. They don't need to worry about your complaint. If they're gonna do the wrong thing, they're gonna do the wrong thing, regardless of whether you've complained or not. The way that I run my cases like, if I was my client, how would I want to be represented? That's how I run my case. So if I know that the judge is doing the wrong thing, I have no qualms about saying to the judge, you're doing the wrong thing here, judge, and I'll explain why. Sometimes my clients get nervous. They're like, oh, Arlene, don't talk too rough to the judge because the judge might not. I said, no, that's what I'm there for. I'm there to advocate for you. It's not a question of talking rough to the judge or anything like that. It's a question of, if I believe that your case has merit and should be presented in a certain way, it's not about whether the judge likes it or not. Their role is to hear the case and decide it on the merits, what's in the best interest of the children, and so on and so forth. So people shouldn't worry, or fathers shouldn't worry that, but in terms of the way they present their case or say something out of turn, or, these are pressurizing situations. Judges are used to people getting a bit irate, a bit angry, a bit frustrated. That isn't going to, affect them doing what's right as far as the children are concerned, or as far as you as the parents are concerned.
So when you go to court, what experience have you seen when people have been bringing partners with them?
Yeah. I mean, at the end of the day, I'm not there as a counsellor. I'm not there to judge anybody. But if you're coming to court as a father to talk about getting access to your child, the last thing the mother of your child wants to see is the next mother in line. Okay. And what I mean by that is someone that is going to be having direct interaction with your daughter. Now, your son or your daughter. Now, the mother of your child may know that you're in a relationship. I mean, I have to say, majority of the fathers do tend to keep that quiet until they're ready to share that. And that can be a source of upset to a lot of mothers as well. They're like, well, why didn't you tell me? I'm thinking, well, no, they're not going to tell you. But worse still, I think when someone just turns up, okay. And in fact, I'm going to give the fathers that are listening permission. You can say to your partner, if they're insisting on coming, I heard this podcast and I heard a barrister say you can't come to court. If that helps you, you can have that. Because I know, we women can be a little bit demanding at times and say, well, why can't I come? And I want to come and I want to support you. That's not the kind of support that fathers that you need. That is just going to be like salt in the wound. Okay. It's too much. It's too much to be going to court and actually having all of that angst and tension and everything else that's going on, and then they've got to deal with the girlfriend or the fiance. I think that the guiding rule is really, if you can come to court by yourself or just with your legal representative, that's the best thing. If your family want to support you, they can meet you for coffee in the morning. You go to court. When the case is over, you can all meet up again afterwards. But, adding more and more people into the mix, it's like I said, it just raises the temperature.
Okay. In terms of legal aid, now, what we usually hear a lot is that a woman, what she needs to do is make an allegation and she gets free legal aid. Is there free legal aid for fathers?
I mean, yeah, the domestic violence issue it's really thorny. I mean, nobody wants to be saying that someone is making an allegation just to get legal aid, but I'm sure that does go on. Equally, though, if a father were to be able to demonstrate that they had been the victim of domestic violence, then the same provisions would apply. Do you know what I mean? It's not gender specific. Okay. I think more difficult is the fact that legal aid, it has been slashed, it has been cut really, really badly, because unfortunately there was a time where people were just taking legal aid for granted. I mean, in most cases, the process does work. It's not enough just to say I've been a victim of domestic violence. You do have to evidence that. You do have to be able to produce documentation that supports what you're saying. But are there people that take advantage of it? Yes, there are. Okay. Yes, there are. But it is available to fathers in that situation will get the same treatment as mothers in that situation.
And how would father go about getting free legal aid if they wanted to go to family court?
I mean, essentially, they'd have to go and find a solicitor. Barristers don't tend to deal with that side of things. And oddly enough, there was a time where, it was basically available to anybody. And at the moment someone said to me they couldn't afford to, I would say, right, I have solicitors that I know that still do legal aid work. I would just send them there. Yeah. Now, it's all about assessment. It's all about what you can prove. So if a father comes to me and says, I'd like legal aid, then I know that there are particular solicitors who, in my book, if they can't get legal aid for you, then nobody can, sort of thing, provided you have the evidence to support that. Do you know what I mean? So, but that is mainly the domain of solicitors. That I know that you can go online and sort of do an eligibility test to see if you qualify. Okay. But you still need to go to a solicitor to actually make that application.
And is that application on .gov?
Yeah, it's the www.gov.uk website. Yeah. Okay. Yeah. Cool. That's the one. That website, I have to say, for all the things the government is guilty of, lack of information is not one of them. It's all on that website is a very good website. Okay.
So if a father was going to a family court, what advice could you give him?
Okay. So there's kind of practical and legal things. The practical things might surprise people, or might surprise the fathers, but I'll tell you them anyway. So normally court cases are listed first thing in the morning, okay? Or you either get a 10 o'clock slot or you get a 2 p.m. slot. Either way, this is one of the things I would say. When you're coming to court, make sure that you bring with you water and a snack and supplies. Things that are going to basically mean that you're not going to get lightheaded, you're not going to get it's the expression hangry. So when you're hungry and you're angry at the same time, because it's a pressurizing situation. Okay. And if you're there and you've got there early, you haven't had breakfast, you haven't had a hot drink, those kind of things, you'll be surprised how they can affect your temperament. Things that people say to you or things that happen in the courtroom or even outside of the courtroom could aggravate you in a way that's different if you had just had something to eat or you'd been hydrated. Also, when you get to court, there's a lot of waiting around. Okay. And again, waiting around, sometimes it gives you more time to think about things that irritate you, things that bother you, things that, so if needs be, because you may be sitting in a waiting room for a long time, you don't always have to talk to your barrister or solicitor. You might have, you might be thinking, I just want to be left alone with my thoughts. If you've got a newspaper or a book or something that just basically just keeps you level. So that by the time your case is called on, if there is a long wait, then at least you're not feeling irritated and frustrated and already riled up, and raring to have a fight with somebody. So those are kind of like the practical things. People always say to me, should I dress up to come to court? Just wear what's comfortable. Okay. Do you know what I mean? Because again, you could be there for a very long time. So there's no point, wearing something that you're going to be adjusting your tie or, you're going to be feeling hot in the courtroom. The second thing is, please turn up on time. Right, there's nothing worse. If your case is on at 10 o'clock, you should be aiming to get there at 9 o'clock, 9:30 the latest, because your advocate, your representative will need to speak with you before you go in. Or even if you're not represented, just come, get the lay of the land, sign in, because you always have to sign in, let the court know that you've arrived, so that you've got time, as I said, just to settle yourself before the hearing starts. If you have a representative and you turn up at 5 to 10 or 10 to 10, they don't have any chance to speak with you. You get rushed into court. And then what happens is when the judge is asking questions about the case, they have to keep, or the advocate has to keep, because the setup is advocates sit on the front row, the father, mother, whoever will sit behind. Your advocate has to keep turning around
just to
find out, to get your instructions. And A, that slows down the process. B, it irritates the judge. And C, makes you look unprepared. Makes you as the father look like you're not concerned about this. And also a bit unsettled as well, because you're not used to the environment. Exactly. Because once you start talking, and there is a bit of a gap between you, you have to either flick your advocate or, to try and get their attention. All of that is not what you want to be doing. So turn up, preferably early, as I said, no later than half an hour before. Most courts will tell you to come an hour before anyway. When you're actually in court, as tempting as it might be to talk up, don't do that. Okay. It just, again, it creates confusion in the courtroom. It makes your case look like it's in disarray. Now, as I said, if there are things that your advocate has left out or not said, the easiest thing, and I know it's old-fashioned to say because we're all of the digital age, just bring a pen and paper with you so you can write a little note or something that you can pass forward to your advocate. Do you know what I mean? So when you say like shout out, is it if someone has said something they don't like and then they're shouting out to that? Yeah. Sometimes it's something that they don't like, or if the judge asks a question and your advocate is saying, okay, I'm going to take instructions, that's not your cue to start talking to the judge directly. Okay. The judge will then say, you've got your barrister, solicitor, whoever there, tell them, and then they can pass it on. And the reality is as well, you get say maybe 30 minutes, half an hour maximum on a short appointment, not a trial, that's different, but on a short appointment, you get 30 minutes, an hour. But again, the judge will have 5, 6 other cases. They need to get to the point, pretty quickly. Yeah. I tend to say to my clients before we go in, look, the fact that I haven't covered something doesn't necessarily mean that I don't know it, but it may mean that for that moment, in that moment, I have to focus on what I know the judge needs to hear. Yeah. But don't think your case is being compromised or prejudiced in any way. Because sometimes a father might think, oh, you didn't say this, but why didn't you say that? And why didn't you say that? This is not, it's not a free-for-all. It's not an opportunity for you to rehash everything that went wrong in your relationship with the mother. This is an opportunity for you to present a case that helps the judge to decide things in your favour. So I would say to the fathers, really, when you're coming to court, just be prepared for that. Be prepared that not everything that you want to say is going to get said, but that doesn't mean that your case is going to be compromised, and you shouldn't shout out if you think something's missing. Okay. Also, things like facial expressions. really, if you're behind, you should not be rolling your eyes. There shouldn't be any sighing, no kissing of the teeth. If you hear something that you don't like, there shouldn't be a lot of action and activity. It should just be, I'm sitting here quietly and allowing the judge to see that I'm a calm person. Because even though they're not talking to you, the judge is looking at you the whole time.
Your body language.
They're looking at you the whole time. If you're agitated and you're, oh gosh, she's lying, she's lying. The judge is like, okay.
Yeah.
I see you, and I see what she's got to deal with. So you're not helping yourself.
Yeah.
You're not helping yourself.
So my next question would be, if a father was looking for a barrister, what would be the process of him trying to get one?
Okay, so one of the positive things that's also come out in the last few years is something called direct access. So historically, what used to happen is if you wanted a barrister, you couldn't just ring up and say, I'd like a barrister. You'd have to get a solicitor and they would then find the barrister for you.
Okay.
But under the direct access rules, basically it means that or public access is sometimes called, it means that an individual, a dad, can actually call up now a barrister's chambers directly and say, do you have barristers that do direct access or do public access? And you get to speak to us, more or less directly straight away without a solicitor. The reason that's helpful is because in terms of what the solicitors do, although it is a bit of a mixed bag now, the solicitors were primarily the ones, as I said earlier, you'd see them on the high street, they'd take your details, hear a bit about your case, and then when you were ready to go to court, so they fill in all the forms, when you're ready to go to court, they'd say, oh, I'll get you a barrister now. Most people, with the help of that website that I was saying, can fill in the forms. The part they struggle with is once in court, what to say, what to do, how to get there and all the rest of it, all that sort of stuff. So if they want a barrister, there are various places they can go. They can either, as I say, almost like looking in the phone book. Yeah. There's a barrister's directory. You'd say, put in direct access barristers. You could do it that way. There are various search engines as well. The one that I'm a part of is called Clerk's Room Direct. Okay. And basically on there, it's like a portal. You put your name, you put in your case, what you're looking for, that sort of thing, a little bit about, whether you've got a court date, that sort of thing. And they will come up with names of barristers. And again, literally, any barristers' chambers will have a pool of barristers, because we have to do extra training for this, that offer direct access services. So we're pretty accessible now, whereas we didn't used to be.
So if a father was looking for a barrister, what kind of things should he be looking out for?
I think that the key thing is that if you're going to family court, get a family barrister. I know that there are other lawyers that might disagree with me, and they will say, well, I specialise I do crime, I do family, I do housing, so I can do it all. My advice strongly would be to get a family barrister. I mean, the equivalent of not getting a specialist family barrister, it's like saying, I want my teeth taken out, so I'm going to go to the local butcher because I know he deals with, cutting things up and taking things, separating things. Yeah. So that's, you just wouldn't do it, or performing, surgery on yourself or getting a friend of yours to do it. You would go to the person that specialises in what it is that you need them to do. And it's really just because the more that you do something, so as a specialist family barrister, I'm in family court, sometimes every day, sometimes a minimum of sort of 3 times a week, 4 times a week. If I'm not in court, I'm advising clients on a daily basis. If I'm not advising clients, I'm writing advices for people that have got family issues, or you're researching the law. So you're sort of totally immersed in that world. The other thing is obviously level of experience. I mean, you can glean a lot of things online. So you could say, what's it like going to family court, and some information will come up, and you can work out whether you need somebody who's very, when I say junior, I don't mean you're their first case. Nobody wants to be an experiment. You know what I mean? But somebody that's had at least maybe 3, 4, 5 years of experience in the family courts. If it's the first hearing, that's probably sort of enough. If you're going into a trial that's got to last 3 or 4 days, or there's lots of complicated issues, there's allegations of violence and so on, you probably want somebody of a senior, what we call a senior junior, which would be, sort of 10 to 15 years experience. But obviously the higher up you go, you've got the cost factor as well. Okay. So you're looking at specialist family barrister or solicitor, and also looking at years of experience. And a lot of times as well, if you put people's names in, even things like Trustpilot, I mean, I know it's a bit risky because it's a bit like trust the trader,
Yeah.
but things like Trustpilot, getting reviews, I get a lot of referrals through word of mouth, people that have said, oh, I spoke to so and so and they told me that you were good. That's probably the best, because they can tell you more about how that person operates as well. Do you know what I mean? But if in doubt, I mean, you can call up and say, can I have a chat with somebody for sort of 5-10 minutes? I mean, I tend to offer 20 minutes for a person to just speak to me without any kind of fee, just so I can they can get a feel from me and vice versa. But but don't take liberties. Don't use that as as an opportunity.
Phone in.
Yeah, I just want 10 minutes.
So is there any general information that fathers should be aware of?
Yeah, I think I was saying this too. Again, this is just over experience. The CAFCAS service, which is basically the welfare organisation that does reports for court and so on, they have a really good website, because on their website there's a lot of materials and resources, things like, for example, parenting plans. So there may be areas that you and your the mother of your child can't agree on, like religion or schooling or health. The parent plan basically highlights all of those things. And if you're struggling, you could say to the mother of your child, look, we're struggling. Why don't we both complete a parenting plan? At least that way we can have an idea about what our expectations are of each other as parents. See where the areas of sort of commonality are and areas of difference, and then see what we can do to kind of resolve them. So I would say something like that is a pretty good resource. Also, we already mentioned the government website. There's lots of information on there about how best to resolve issues that come up between you. I know you had a family mediator on as well. The mediation service as well is pretty good.
Okay.
Again, it's just as long as people are willing to be open and honest and engage properly.
One more question. About is it?
CMS now.
There you
Child
go.
maintenance.
I keep thinking that wrong,
The child maintenance
But
service.
With that now, how can fathers go about that if they're being put onto that? Because I know there seems to be a lot of mixed messages what seems to be going on.
Yeah.
So what advice could you give on that to fathers?
Yeah, the child maintenance service is a really odd animal, because it's there obviously to ensure that it is, again, primarily fathers take financial responsibility for their children as well. That process is quite intrusive, because they have the power to go to the Inland Revenue or HMRC, look at your records, see what you're earning, go to your employers, take money out of your wages, and it can get very hostile. I would say, if at all possible, try to make an arrangement with the mother before it gets to that stage. For two main reasons. One, because as I say, it's a contentious organisation. When people think I've been reported to the CMS, normally it's not a positive thing. You know what I mean? And that already,
it's never positive.
No, exactly. That already tells you that there are problems. And also because the CMS, your child doesn't get all the money that goes to the CMS. They take a fee out of it as well. So, mothers that think I'm going to the CMS as if that's a threat, they can end up with less than they thought they were going to get.
It's happened many times.
Yeah, because the CMS take their funds out of it. I mean, the only other thing that I would say is when, and this is slightly going back to preparing for court and what have you. I'm not trying to necessarily say that, you should pay money to see your child. I think that is, that's a complete misunderstanding. Nobody pays money to see their child. I know it may feel like that. It may feel that, well, when I'm paying, then I see it. If I don't pay, it's all about the whole thing about surrounding parental responsibility, because a lot of times what tends to get lost in translation, if you like, is that your child, when they're in their mother's home, they still need electricity, they still need gas, they still need water, they still need food. Those are things that the CMS doesn't really think about. They'll say, okay, pay this money and it'll be used for maybe school uniform and things, school books or what have you, but they don't think about the day-to-day utilities. So one of the things I would say is that if at all possible, if you can make some sort of arrangement that allows you to support your child living with their mother, in other words, like I'm saying, gas, electric, food, heat, water, basic amenities, that can also sometimes go a long way to helping the relationship. Like I said, you're not paying for your child, you're not buying your child's love or buying your child's time, but it just sends a message that actually you're committed to everything that child needs, not just the fun stuff, not just the trips to McDonald's or whatever, but you're committed to their day-to-day well-being. Do you know what I mean?
Yeah, I hear that, but I have to agree and disagree on some of that, because I do know that some mothers use it as a weapon to take fathers to CSA, and they don't even try to sit down to negotiate with a father.
Yeah.
And then he's then kind of cornered because she ain't trying to compromise. She's trying to hit him for more money. Yeah. And then he's got CSA taking money from him if he decides not to pay.
Yeah. No, I hear that. And, as I was saying earlier, there's sort of pros and cons, there's good and bad. I know that there are, mothers out there who do use it as a weapon. Equally, I know, like I'm saying, from the father's perspective, the idea of handing over, I've had fathers say to me, oh, she's going to go and get her eyelashes done. She's going to go and get her nails done. I'm like, well, okay, she may be getting her eyelashes and her nails done, but she may not necessarily be using your money to do it. You know what I mean? Yeah. So that's what you got to understand. I think, again, just trying to take the heat out of the situation. And there's nothing wrong with fathers. As a father, you can refer yourself to the CMS. You may not want to do it, but in some ways, that is the best way to make sure that you're fulfilling your responsibility as a father. There's a record of it, because that's the other thing. I know fathers that have handed over money, and then when the CMS come around and say, oh, have you been paying? And you say, yeah, I've been paying. And they say, okay, where's the record? Oh, I gave her cash. Yeah. Don't ever go down that road of just handing over actually, let me rephrase that. If you're not bothered about whether there's a record, by all means, hand over cash. Yeah. But if you want to be able to evidence, then put it in a bank account, do a bank transfer, that sort of thing.
So the other day we had a father on our show, and they literally took the house off him while the woman was still living in there. How is that able a thing?
Were they married?
Yes.
Okay. So that's kind of, I have to put my divorce lawyer hat on for that.
Yeah.
So and they had children.
Yeah.
Okay. So basically, when it comes to separating out finances on divorce, the starting point is 50-50. Okay. And that's regardless of who bought the house, because I've normally fathers will say, but I paid the deposit and I paid the mortgage and
he pays the bills and everything.
I paid the bills. That's not necessarily the test. That's one of the factors, but it's not necessarily the overriding factor. So the starting point is, to be fair, this was a marriage, it was a partnership. Maybe she stayed at home and looked after the children, or maybe was only able to work part-time.
Yeah, she was working part-time.
Yeah. So her contribution was looking after the kids so that the father could basically work full-time. So they see it as a partnership. So the starting point is 50-50. Usually, as a result of that mother taking time off, maybe working part-time, they may not have, for example, built up their earning capacity, might not have things like pensions if they haven't been paying into. So when the court looks at it on paper, the father looks like he's more likely to be able to get another mortgage. He's more likely to have maybe build up some savings, have pensions and so on, be more financially secure. So what they tend to do is when you say hand over, and obviously I don't know the precise circumstances, normally they hand over, but only until the youngest child either reaches 18 or completes full-time university education, at which point the house is usually sold and the father gets their share at that point. Okay. So even though it may feel like it's all been handed over, and I'm talking generally because I don't know all the circumstances, it's a temporary handing over, because the court recognises both parties are entitled to share, but because of the way that they've managed their finances up until that point, it may be that the mother needs more help at the start. Okay. Father can cope for now, and then later on he'll be able to take his share out later. Okay.
So Arden, listen, we're going to wrap it up now because we've run out of time.
Yep.
But I want to say thank you for coming down today. It's definitely been an interesting conversation with you. Is there anything you would like to say before we finish?
I think just if I was going to leave anything with the fathers, and I know that this is difficult at times, but just try and put yourself in the other person's shoes. Just think about, okay, if I was in this position, what would help me to make this situation a little bit easier? Don't get me wrong, I know that there can be very, very difficult mothers.
Yeah, but I took the words out my mouth. Go on.
I know there can be mothers that kind of attitude and everything, but just try and put yourself in their position. There may be other things going on in their background, in their life, that is feeding into, you know, how they're interacting with
Their
you.
childhood as well, you reckon?
Their childhood, you know, things that have gone in, they've seen when as they've been growing up, or even other family members that have gone through things that have influenced how they see the world. So just try and take that into account. And also, I think I said this earlier, just persevere. You know, it breaks my heart when a father says, you know what, I'm just not going to bother. They can come and find me when they're 18. A lot of times they won't come and find you when they're 18. Or if they do come and find you, it will be basically to tell you about yourself and say, why didn't you, you know. So just persevere, you know, just think about, my child needs me. We've got enough fatherless children growing up. We don't need to be adding to that number.
Okay. Good way to finish it.
Good.
Yeah. So listen, people, I want to hear your views in the comments below. I want to hear your thoughts on today's show. Make sure you subscribe to the channel and don't forget to give us the like. So from next time, from the Baby Fathers, peace. And we out.